Thanks for staying with us. Let's go to this now. The Western Cape High Court has declared President Cyril Ramaphosa's decision to suspend Public Protector Advocate Busisiwe Mkhwebane invalid. Mkhwebane's suspension has effectively been set aside from today. The Public Protector asked the High Court to declare certain conduct and or decisions of the National Assembly Speaker, the Chair of the Section 194 Committee and the President irrational, unconstitutional and invalid. Mkhwebane was suspended in June and is currently participating in a parliamentary inquiry into her fitness to hold office.
5-10 minute break. Someone has just walked into our room here, and we just need to have a quick consultation. We've just received the judgment from the Western Cape High Court that the suspension of the Public Protector has been set aside.
All right, let's speak now to Advocate Modidima Mannya, who is a legal analyst who's going to be speaking to us about this particular matter. Advocate, thank you so much for your time. Your reaction to the ruling?
Well, you know, early days to comment. I haven't read the judgment, and I understand the principle. The court has already made a ruling, the Constitutional Court, in the state capture matter, where and the Sean Abrams matter, that the president should not exercise the power or perform his functions as head of state, but leave it to his deputy. And I suppose this is the same principle. But whether the facts of this matter will find favor with the Constitutional Court to confirm that is another matter. But as matters stand, the Western Cape High Court has said that the decision is invalid. Of course, it's not with immediate effect because it's subject to the confirmation of the Constitutional Court. So until the Constitutional Court makes a decision, the decision is not of force and effect.
Please bear with me because I'd like to read this part of the judgment and get your sense on really what we should be reading here. It says in paragraph 159, it was submitted on behalf of the president that he was empowered by Section 194 of the Constitution to suspend the applicant. It was also contended that the suspension of the applicant was based on her incompetence as detailed in a number of judgments, and that the president could have suspended her long before the 9th of June this year. It was further argued that the applicant's suspension had already commenced well before her letter was addressed to the president on the 7th of June. Furthermore, that the suspension of the applicant makes no difference to the president in that, notwithstanding the applicant's suspension, the investigation against the president is continuing with the acting public protector at the helm of this investigation. It continues. That may be so. However, this argument, in our view, misses the point. In this case, one has to draw a distinction between the process relating to the applicant's suspension, which commenced on the 17th of March when she was requested to furnish the reasons why she should not be suspended, and the decision to suspend her, which was taken on the 9th of June. What is relevant here is the decision on the 9th of June. In our view, it was still open to the president, after considering the representations of the applicant, to decide not to suspend the applicant. However, from the objective facts, the decision of the applicant to investigate the president and put 31 questions to him prompted the president not to wait a day more and to immediately suspend her. Clearly, when the events that unfolded between the 7th and the 10th of June are discussed above, are objectively examined, it is irresistible to conclude that the decision of the president was improper. I know that was a lengthy paragraph to read from, but it's important because it forms part of the basis of the argument by the lawyers that the president moved to suspend at a time when he should not have.
Yes, look, it's not unusual that the court would draw adverse inferences which may cast aspersions on the decision maker. And I think in this particular instance, the court seems to have drawn an adverse inference. Obviously, the timing of the matter is important. And as a matter of fact, yes, the president could have acted earlier. You know, it may not be far-fetched that the letter, as the court found, prompted him to act swiftly. You must bear in mind, I think, that you know, the suspension happened a day before a judgment was delivered. Of course, the judgment happened to be against the public protector. So I suppose when the Constitutional Court looks at the matter, it will take those type of factors into account.
And do you think, though, if the president had acted earlier, I just had a conversation with Kaya, who says that had the president pulled the trigger, if I may put it that way, early, the judgment could have been somewhat different. Would you agree with that?
Yes, I think that, I personally was concerned about the fact that this happened, after this letter. And it may as well be that the president meant good and he was following the procedures. But the reality is that in a dispute, one party will make allegations against the other and the adjudicator will have to take a position one way or the other.
Now, when we then, leave that for a second and go into the inquiry itself, because we saw quite a lot happen after, that break after a week and a couple of days. The issue of the legal, fees has now come into sharp focus. Quite an amount, really, that boggles the mind. About 147 million being used when it comes to legal fees, and this is a tally, of course, by the evidence leaders. They say since she took office, and they talk about how this is, one of those indications that she did not prevent fruitless and wasteful expenditure. At the same time, you have her lawyers saying this is sensationalist, as it presents a skewed picture, because no one is asking what the president has spent when it comes to his legal fees defending one or even many other matters against him. What did you make of that argument?
Bongi, and let me not speak as a lawyer here and speak as a former administrator. Every state department or entity is given a budget. And the Public Finance Management Act is very clear that if your budget is 371 million, for instance, in the case of the public protector, there is this allocation for personnel costs, which I understand takes about 75%. So effectively, for goods and services and other things, the public protector is left with about 80 odd million or 100 million. Now, if the public protector were to spend, whether justifiably or unjustifiably, an amount in excess of the balance, that simply means that there's no money to do any other thing. And as an accounting authority of the public protector, she would have breached the Public Finance Management Act, no doubt about it. She can't plead necessity because while there might be a need, there is an issue of compliance. And I think in that sense, the evidence leaders make a point. I think it's not even a question of comparison of how much the president or any other minister spent. It's about whether she lived within the budget in terms of the applicable laws.
And there's another issue that, has been recurring since the beginning here, and it's been the run-ins that from time to time we see between, her advocate and some of the members of parliament there, but also even with the chair. Today, for example, things even getting to a point where Advocate Dalimpofu saying she's the reigning queen of clean audits, and then the chair saying you must respect us, and you're hearing even from the other MPs saying you need to respect us. What does this do for the decorum of this particular process?
Bongi, you have watched the Senzo Meyiwa trial, and you have seen what Judge Maumela has gone through. He has had to say to people, sit down, and they would argue with him. But I think to get an answer to your question, take the Senzo Meyiwa trial. There's a state prosecutor there, Advocate Baloyi, and look at his demeanor and decorum and conduct, and that is the standard. Anything outside of that is something else. Look at Advocate Bawa and Advocate Mayosi, that is the standard. Anything else is not the standard. And I think that's as best I can answer you.
All right, let me thank you for your time this afternoon. We do appreciate it. That is Advocate Modidima Mannya, who is a legal expert, just giving us his reaction to the ruling by the Western Cape High Court. And of course, this is with regards to the public protector suspended, Advocate Busisiwe Mkhwebane. We are still, of course, waiting for this decision to then head to the Constitutional Court for either it to be thrown out or